Okay, Caroline, Chuck, Curtis, everybody ready to go here?
Yes.
Mr. White, have we let everybody into the room? Or are you going to just keep letting them in as they show?
Yes, Your Honor. I'll monitor it. And keep
perfect. All right, looks like we're up to 30 already. This is great on a holiday in the mainland and Tuesday in Guam. So for all of you on the islands, half a day. My name is Judge Collins. I'm a bankruptcy judge in Phoenix, Arizona. Also the backup judge for Judge Tynico Gatewood in Guam. When she has a conflict in the bankruptcy arena, she calls on me. Over the years of doing that, I've come to meet Mr. Choi. He is a bankruptcy lawyer from Honolulu, very experienced Chapter 11 bankruptcy lawyer in particular. Mr. Choi worked in Los Angeles for a number of years, but in 1995, he moved back to Hawaii, and I've seen him in quite a number of cases. And my colleague in Hawaii, Judge Ferris, has good things to say about Mr. Choi. And so, Mr. Choi, thank you very much for taking your time on what is your President's Day. And so thank you for joining us. Next, I'd like to introduce you to Caroline Djang. Caroline, I've met over the years in different bankruptcy gatherings, particularly in California and on the national scene with the American Bankruptcy Institute, the National Conference of Bankruptcy Judges, and so on. But Caroline in particular, we wanted her here today because she is a Subchapter 5 trustee. We'll explain a little bit about what exactly that means. She's practicing at the Buchalter firm in Los Angeles. And Caroline clerked with 4 or 5 bankruptcy judges over the years. And so she's got a wealth of experience in the bankruptcy world, both behind the scenes and out front in court. So Caroline, thank you very much for taking your time. I know you just got off of a flight, but you're ready to go, right?
Yep. Thank you, Your Honor.
Thank you for joining us. Now, a lot of you on screen know Curtis Ching. Curtis is with the United States Trustee's Office. It's a branch of the Department of Justice. And if you've done any bankruptcy work at all, you're likely to have run across Curtis because the U.S. Trustee's Office is an oversight role. We're going to talk about that a little bit more, but Curtis and I also did some CLE programs in Guam, and Curtis, it's really a pleasure to have you here. You're a real professional, and I know you and Mr. Choi have run-ins periodically, but I think he's got a high regard for your professionalism and the work you do and the energy you bring to your cases. So Curtis, thank you for taking this holiday day to spend a little time with us. Curtis, by the way, is sitting in or is working out of the Honolulu office of the United States Trustee. So with that, let's go ahead and just jump right into it. What I'd like to do is do a little screen share here and bring up a PowerPoint that was prepared by our panelists here today. And let's go right to the top. So all of the participants today have their name and address and email information at the very last slide. You're all going to have this slide available, or rather the entire PowerPoint, to all of you. I think it's fair to say that Chuck and Caroline are very much interested in talking with you if and when you've got a bankruptcy issue. This is how bankruptcy cases come to them, and I think they'll be very pleased to be able to hear from you if and when you have a bankruptcy issue and need to bring it to somebody who's a real experienced pro. All right, let's go ahead. Caroline, why don't you talk in very broad sense, first of all, what we're going to be talking about today, consumer versus commercial, or appeals even, which we did last Monday. Talk about the commercial side and how you view, as an overview, the bankruptcy reorganization process and what it does.
Well, thank you, Your Honor. Again, I'm Caroline Djang. I've been practicing bankruptcy for now 23 years. And as Judge Collins mentioned, I started my career clerking at the bankruptcy court, and I was there for 7 years. So now I am a shareholder with a law firm called Buchalter. We have 450 attorneys. We have about 25 bankruptcy lawyers all along the West Coast. And I specialize in Chapter 11. I do Chapter 7 as well, a tiny bit of Chapter 13, but I'm not great at it. But Chapter 11, as you know, is a reorganization as opposed to a liquidation. And we're going to talk about Subchapter 5, but in Chapter 11, you have what's called the debtor in possession. So unlike in Chapter 7, when the debtor files, you have a trustee come in, they take possession of the assets, they liquidate your non-exempt assets, pay your creditors, and you're done. Chapter 11, the debtor stays in possession for the most part. And the debtor operates its own business and stays in control of its assets, et cetera. So this is both me and Chuck. We'll talk a little bit about the hypothetical client that calls me up. And I do get a lot of calls for Chapter 11. I think most lawyers and most people typically just have a layman's knowledge of what Chapter 11 is. And what I usually say is, well, it's the ones you hear about in the news, like Bed Bath & Beyond and 24 Hour Fitness and Hertz. The big retail bankruptcies are typically going to be Chapter 11s, except Soup Plantation. I don't know if that's out in Guam, but Soup Plantation was one of my favorite restaurants. And they filed a Chapter 7 because they're a buffet style restaurant. So in the pandemic, they just said, nope, no buffet. That's not that business model no longer works. Although I just read today, they're reopening a Soup Plantation in Tucson, but I digress. So in any event, that's usually how I describe Chapter 11. That's the ones you've heard of in the news. These are companies that are reorganizing. They're not closing their doors. They're not handing their keys to a Chapter 7 trustee. They're trying to make a go of it for whatever reason. One of them in those retail bankruptcies that I mentioned, a lot of those file so that they can shed their bad leases. 24 Hour Fitness is a perfect example of that. They had good locations and bad locations, and 24 Hour Fitness is still here. So they closed up their bad locations and they rejected those leases. So that's one typical problem. Lawsuits is a big one. Obviously, if you're getting sued and you can no longer afford to defend, I would say that is my number one client. Especially since I work at a full service law firm and I have litigation attorneys in my firm who say, they can't afford to defend this anymore. What do you think, Caroline? So I talk to them. Foreclosures, another big one, real property. You can't pay your mortgage, foreclosure sale. This is the kind of case that people file on the eve of bankruptcy, as they say, to stop a foreclosure. That's very common. Choi, Chuck, did you have anything you wanted to add here?
Yeah, I think we're really kind of the last stop, so to speak, for
Right.
a business.
Last resort.
And the business owners that come to us, we're in a different market, obviously, than Los Angeles. They're small business owners, and their agenda is interesting. They want to hang on to the business. They want to pay what they can to their creditors. But the real challenge is explaining to these business owners that there's a price that you have to pay in a Chapter 11. A regular Chapter 11 is a very difficult process. It's expensive. It'll last, a year or longer. And there's something called the absolute priority rule in a regular Chapter 11, which essentially says that if a creditor that is not paid in full objects to the plan, based on the absolute priority rule, the bankruptcy judge cannot allow the old equity to retain their equity through confirmation of a reorganization plan, unless there's some new value that's contributed by old equity. Now, new value just means cash, essentially. The real challenge for these small business owners, frankly, is they're just out of resources. Many of them I've seen raid their 401k, mortgage their homes, and they literally themselves are on the verge of Chapter 7. And they want to hang on to their business. And that really is the kind of business that is ideal for the sub-Chapter 5 bankruptcy, which we'd like to focus on today because we think it is something that Guam practitioners ought to consider.
So Chuck, one of the things that I have not heard is that a bankruptcy could be in a Chapter 11, a liquidation. Is it possible to liquidate the company in a Chapter 11? And if so, why would somebody want to do that rather than just let a Chapter 7 trustee do it?
Well, the business owner knows his or her business and the market better than any Chapter 7 trustee, with all due respect to Chapter 7 trustees who by and large do a very good job. And Chapter 11 gives the business owner the ability to wind up the business in possession, kind of on a relatively, short time frame, and pay their creditors as much as possible. So oftentimes it is much more efficient because creditors get paid sooner. In a Chapter 7 liquidation, it really is unusual for a Chapter 7 trustee to be able to fully administer a case, file the necessary reports, get the court approvals and so forth, and make a distribution in under a year.
So it's possible to do a liquidation sale in a bankruptcy, but there's lots of other reasons to have it as a reorganization, a restructure of the debt. One of the things we have on screen here is conflicts. Caroline, talk a little bit about the conflict issues that you think about when a person comes to you or a company comes to you with possible bankruptcy.
Sure. And being at a 450 attorney firm that's almost 100 years old, I get a lot of issues with conflicts. And that usually means that my firm represents a creditor and my firm represents a lot of banks. And even though I don't necessarily represent that bank. There are very strict ethics rules here, just generally speaking, but also my firm. We don't want to look bad to other clients. We don't want them to see a notice in the mail that says this company filed bankruptcy and they are represented by Buchalter, and that client, this company is someone that, the bank X is also represented by Buchalter, and they say, hey, how did this happen? So I struggle with that very frequently. I actually was just writing a memo about how I turned away three Chapter 11 cases just this year because of conflicts. It's actually probably more than that. But also you have to be fully disinterested. And that's a definition under the bankruptcy code. You can't be owed any money. So that's a common problem that you see when it's an existing client and say you've been handling their litigation and they say, oh, well, I want to talk to your bankruptcy lawyer and it's Caroline. And I say right away, they cannot owe Buchalter any money if we're going to be their counsel as a debtor in possession. Either we waive the money that we're owed, which is not typically going to happen, or they need to move on. And I have a whole slate of firms that I refer to because smaller firms aren't going to have as much of a conflicts database. But yeah, it's again, as we said, it's very important for your client to understand this from the beginning.
Yeah, if I could just interrupt and jump in here. It's also important for the client or the debtor in possession to understand that they now have a fiduciary duty, to their creditors, and that really the whole process, the bankruptcy process, the Chapter 11 process, is about maximizing the return to those with the least leverage in a bankruptcy case. And I'm obviously not talking about the bank or a landlord or the taxing authorities. I'm talking about general unsecured creditors. And the other thing that potential debtors also need to understand is Caroline, myself, any lawyer for the debtor represents the debtor and not the individual. Outside of bankruptcy, they're just used to telling their lawyers what they want. And the lawyer says, yes, sir, yes, ma'am, and moves on. In a Chapter 11, we sometimes get into loggerheads with the client because the client doesn't appreciate that he or she just can't run the business the way they want.
So Curtis, one of the things the United States Trustee's Office does is look at professional retention by the debtor. What are some of the issues that your office flags with respect to conflicts?
Yes, thank you, Honor. So definitely what Chuck and Caroline are talking about, the conflicts issues, the representation of if you're representing the debtor and they owe a debt, certainly look at that. But also it's very important for the practitioner to understand that that disclosure in itself becomes an issue, even if the disclosure, so any connection that the attorney has to the creditors and other parties in interest has to be disclosed, even if it doesn't arise to the level of a conflict. There's a lot of case law out there that says that the lack of complete disclosure separate from the issue of whether or not they are disinterested and have a conflict, the lack of sufficient disclosure is grounds to deny retention or deny compensation. So disclosure is a really big thing.
Yeah, the last thing you want to do is get involved in a case like a big Chapter 11 or even a medium-sized Chapter 11 and fail to make some disclosures and find out that the court's going to deny your compensation well into the case. Total disaster scenario for a debtor. All right, so let's jump into who is who in bankruptcy and some of the players. Let's start with the U.S. Trustee's office, even though that's the third one there. Curtis, why don't you describe a little bit about your office, please?
Yes, we have a slide later on this, but I can just cover it very quickly now. The U.S. Trustee's office, as Judge Collins mentioned, is part of the Department of Justice. So we have a large watchdog role for Chapter 11 cases, but we also have very specific duties in Chapter 11 cases. So we have the standing to appear in pretty much any matter, though in practice, we don't appear in everything. You'll see us most commonly at the beginning and near the confirmation stage of the case. So at the beginning of the case, you're going to get a lot of correspondence and communications from us to set up interviews, to ask for a bunch of documents, tax returns, bank statements, proof of insurance, all things that you need to disclose to us and to the court to make sure that you're operating properly. We set up an interview and called an initial debtor interview. And we also schedule the meeting of creditors where the debtor appears and testifies about their financial affairs and their plans going forward. We also look at monthly operating reports and make sure the debtor understands the important responsibility of filing monthly operating reports to ensure transparency in the financial process.
Okay, great. Well, Chuck, you're usually at the debtor side, correct? So why don't you talk a bit about the debtor, because the debtor is not necessarily an individual or a company. It could be a whole series of affiliates. You want to talk about that and what controls where they file? You're on mute, Chuck.
Excuse me. We're going to focus during this seminar on subchapter 5 cases. And subchapter 5 is a chapter 11 case for small business debtors. And before I talk about the debtor side, I think Caroline has some very interesting statistics. I can tell you personally that in Hawaii, in 22-23, we filed, and I'm not at a big firm like Caroline. We have 2 partners, enough counsel. We filed 10 subchapter 5 cases and just 2 non-subchapter 5 chapter 11s. Okay, so I'm a fan, but Caroline, tell us about the statistics that would prove my hunch here.
Yes, you're correct. Subchapter 5 is extremely popular, especially in my district. I'm in the Central District of California, and for those of you who know California geography, that's LA, Santa Barbara, Orange County, Riverside. It's very large. It's the largest geographic district, largest population. But we have the second most subchapter 5 cases in the country. The first is the Middle District of Florida. I don't know why that is, but Judge Bonifel, who is the subchapter 5 expert, said it's both districts that have a Disney park. So I don't know if there's correlation or a coincidence. But in any event, since the beginning of the program, there have been 394 cases in the Central District of California. We actually have 9 subchapter 5 trustees, and I have been assigned about 35. I say about because I had one debtor who filed 3 times. So I don't know if I counted once or counted 3 times. In any event, Chuck is absolutely right. For those of you who ever did the small business chapter 11 prior to SBRA, I never did them. Even as a law clerk, I saw maybe 1 a year. Those have totally dropped off, and for good reason. Their confirmation statistics are very poor. The confirmation rate for subchapter 5 from 2020 to 2023 was 48%. For non-sub 5 chapter 11s, it was only 20%. And this is my favorite statistic. Median months to confirmation, only 6.4 months to confirm a subchapter 5 plan, but 10.3 months for regular chapter 11. And 10.3 even sounds quick to me because in my experience, traditional chapter 11 is like a full year at least. That's kind of what I tell people, bank on a year. I just confirmed a subchapter 5 plan from the debtor side in 6 months. And that to me is kind of unheard of. And it wasn't, I mean, a small business like they all are, but it wasn't uncomplicated. We had very, very large claims. We had a very large piece of litigation, and then a couple threatened pieces of litigation. So 6 months is an incredible statistic.
So Caroline, let me jump in with a few more statistics, because the truth
Sure.
is the reason we're having this 3-part series on bankruptcy is Judge Tidingco Gatewood in Guam said, you know, we're starting to see some more bankruptcy activity, and we really want people on the island to feel comfortable with bankruptcy and be willing to delve into it, and if nothing else, be able to spot some issues. So at a national level, when you compare January of 23 versus January of 24, there's been a 17% increase in bankruptcy filings nationally. With respect to commercial bankruptcies, it's a 21% increase. And specifically with respect to subchapter 5 bankruptcies, year over year in January of 23 versus 24, 43% increase in subchapter 5 bankruptcies. It really is catching on, and it really is the reason we're talking about in the commercial context, subchapter 5, because it's a smaller bankruptcy. We'll explain how so, but it's really happening everywhere. And it's starting to happen in Guam, and Chuck has even filed 1 or 2 in Guam.
Right, Judge. I think that it is, for lack of a better description, a consequence of, obviously, higher interest rates, but sort of the COVID hangover. I mentioned a few minutes ago that in 22 and 23, we filed more than a dozen Chapter 11 cases here in Hawaii and 1 in Guam. But what I didn't say was that in 2020 and 21, when I thought I'd be very busy, when my phone was ringing off the hook because COVID was, forcing businesses to shut down or close shop for a long time, we didn't file any Chapter 11 cases. Why? Because there was just so much money sloshing around in the system, right?
That's right.
Idle loan, PPP, ERC, you name it. And people had the liquidity to ride out COVID. But I think you're right, Judge. There's definitely a trend for more commercial cases.
And I was just going to say there was also the moratoria, the eviction moratoria. So I think, the last statistic I wanted to mention was actual Chapter 11 versus sub 5 percentage. And here in the Central District, the first full year of sub 5 of SBRA was 2021. It was 36% of Chapter 11s were sub 5s. In 2023, it was 63% of all Chapter 11s were sub 5. And in LA alone, in Los Angeles, it was 90% of Chapter 11. So in LA alone, that's just the Los Angeles division that's located in downtown LA, there were 21 Chapter 11s and 19 were sub 5s. So it's pretty overwhelming in some districts, and LA being one of them, the popularity of sub 5 over traditional Chapter 11.
So Caroline, you are often appointed a sub 5 trustee. That is a different sort of animal than other kinds of bankruptcies. Tell us specifically what's different about sub 5 trustees.
That's exactly right. We have a completely different role than a Chapter 11 trustee, a traditional Chapter 11 trustee, a Chapter 13 trustee, and a Chapter 7 trustee. Our statutory duty is to facilitate the development of a consensual plan. That is the one piece of guidance we have from the code. Other than that, there are other duties that we borrowed from Chapter 7, like objecting to claims and things like that, making appearances at certain hearings. We have to appear at every hearing that has to do with the value of encumbered property, confirmation of a plan, sale of property. And we also have to ensure that the debtor makes timely payments under their confirmed plan. But the big one there is the consensual development of, the development of a consensual plan. And actually, here in the Central District, we are all trained mediators. We did it over COVID, so we were able to do Zoom, 4 days of Zoom mediation training, because that is, our judges believe, really our role. It's a facilitative role. And so we need to be able to mediate between debtors and creditors, and therefore we all are mediators. So it's a very different role. And there's a really great case, and I don't have the name in front of me now, but if anyone's interested, I can tell them later. I talked about this at NCBJ. It really lays out the duties, and it talks about how a Chapter 7 trustee can actually be quite adverse to the debtor. When they're, for instance, if there's a turnover issue, you know, that they are an absolutely adverse relationship. I don't feel adverse to my debtors at all, because again, the word is in the code, facilitate. So I'm not there to collect assets, etc. And we'll talk a little later about what happens when the debtor is removed from possession for cause. That's a different story. Then my role changes, and it becomes more like your traditional Chapter 11 trustee, who gets appointed when there's fraud, dishonesty, incompetence, gross mismanagement, etc. So it's kind of the same criteria.
So when I have a sub 5, I always set an initial conference. And one of the things I tell people is pretty much what you were just saying, that is a trustee in a subchapter 5, maybe not your friend, but they are really there to help you. And I think one of the reasons that it's structured that way is that in a big Chapter 11, you're going to often hire outside expertise on how to restructure, a chief restructuring officer. The
Yep.
smaller cases can't afford that. But yet
Correct.
somebody like Caroline, as a subchapter 5 trustee, brings a wealth of experience to the table and can help you find out how to get your footing here to get a confirmed plan, hopefully a consensual plan. So that is a very big change in Chapter 11, but there's a cost that comes with it. One of the things I want to do is shift past our last slide, which also talked about creditors and the judge. I think everybody kind of knows what that's about. But I want to bring in some of the detailed points that we want to touch on, and why subchapter 5 is different than regular Chapter 11. So Chuck, let's talk a little bit about eligibility, if you would please. That's a crucial difference in subchapter 5.
Sure. You know, and like in a Chapter 13, there is a debt limitation. But and that number is 7.5 million. During COVID, Congress increased the debt limit for small business Chapter 11 cases from, I think, around 2.5 million to 7.5 million. And that law has been extended. It's due to sunset, I believe, June or July of this year. Hopefully, Congress will extend the higher debt limits further, because 7.5 million, frankly, is an awful lot, because that applies only to, quote, liquidated debts. In other words, debts that are contingent, disputed, or unliquidated don't count. You can fit in an awfully big business under the debt limit. In fact, Caroline was telling me a week or two ago that she heard about a case where literally the legal fees were well into the 7 figures, Caroline, for that case.
Yeah.
Because it was a very large business. There was lots of litigation. Now, the truth is, the subchapter 5 was intended for small businesses. You know, it's intended to be cheaper and faster. And as Caroline mentioned, you can, you know, often get to a confirmation hearing within 6 months, because the bankruptcy code requires the subchapter 5 debtor to file a plan within 90 days. And that seems like an awful short time frame, but I want to assure the practitioners that subchapter 5 is form driven. It is not as complicated as a regular Chapter 11. There are fewer issues to litigate before a judge. So, you know, 7.5 million in liquidated debts. If you're under that, and if you are not a you know, single asset real estate entity, then you, whether you be an LLC, a corporation, or even an individual engaged in business, can qualify to file a subchapter 5 petition.
I had a subchapter 5 in Arizona where there was lots and lots and lots of contingent liabilities, disputed liabilities, hundreds of millions of dollars.
Yeah.
And yet their undisputed liabilities were under 7.5 million. And so we had some big litigation going on, and yet it fit within the 7.5 of the subchapter 5. And as a result, it turned out to be a case where the debtor could confirm a plan quite a lot easier. Let's talk about some of the reasons that it is easier, Caroline, to confirm a Chapter 11 plan that is a subchapter 5.
Right. So, and piggybacking on your last comment, Your Honor, there was a case in the Northern District of California, that's the San Francisco area, that had many millions of contingent debt that were lease liabilities. So in bankruptcy, you know, there's some debate now. There's some case law that says the opposite. Do you count leases, rejection damages? This court found that you don't. This was a restaurant chain called Sizzler. I don't know if you know Sizzler, but like Soup Plantation, it's kind of like that. It's a kind of typical American steakhouse restaurant. And Sizzler, you would never think would qualify for subchapter 5, but they did if they shave out their contingent lease liability. So I believe the reason why it's so much easier, and we have on the slide, no disclosure statement. So that's a cost saving thing. And one of the things about subchapter 5 is the plan has to have certain requirements in it. And a lot of that, what we typically put in a disclosure statement is part of that requirement. You have to give the background of the debtor. You have to give the reasons for filing bankruptcy, things like that. Things that you would normally find in a disclosure statement are now required to be in the plan.
Let's
But
talk a second about what is a disclosure statement, because some people are not going to know what that means. If you go to
Okay.
issue stock, the SEC wants you to issue a prospectus so that people know what it is they're buying. In
Yep.
bankruptcy, a disclosure statement really fulfills that role as well, doesn't it?
Yes, exactly. It's the disclosure statement is exactly what it says. It has to disclose, it has to help the reader determine whether to vote yes or no on the plan. Is kind of the shorthand version of what a disclosure statement is. In a subchapter 5 case, there is no disclosure statement. It's just one document that you look and see, how is my claim being treated? And then you literally fill out a ballot. And we still have balloting. There was that debate too at the beginning of sub 5, whether we needed balloting or not, because there's no absolute priority rule, which is also a big cost. I mean, and Chuck already mentioned this at the beginning. This allows equity to retain their interest, new equity to retain interest in the old company without paying unsecured creditors in full. So that is a game changer. I think the absolute priority rule is the biggest game changer of all. But to also the best interest rule, which is 1191, and that is, and you may have heard this before, essentially it is kind of a hybrid situation where the debtor pays off over time, usually 3 to 5 years, minimum 3, maximum 5, all net disposable income. And that language kind of mimics chapter 12 and chapter 13. And there's been developing case law on it, like they don't want someone to say, well, as part of my net disposable income calculation, I need to drive my Lamborghini and I need to, you know, pay my mortgage on my $11 million home, things along those lines. Thank goodness the case law is developing on that. But that to me is also the biggest change. Regular traditional chapter 11, there's no such thing as, oh, we just pay disposable income. I mean, you could, I guess, you could do anything you want, but this is how most subchapter 5 debtors confirm a plan. And I was just in a confirmation hearing a month ago where it wasn't my case. I was just waiting for my matter to come up. And our chief judge, Judge Albert, who was a former alum of Buchalter, he said to the whole courtroom, he said, you know what, I'm going to confirm today. I really don't want to. I don't think this is fair. It was a 0% plan, which those of you who practice chapter 13, there are 0% plans in chapter 13 that get confirmed. But Judge Albert just said, the code says I have to. If the debtor is putting in their disposable income, net disposable income over the period of 3 to 5 years, it is, quote, fair and reasonable. So I think it's a lot easier to confirm for that reason.
Can I ask Judge Collins this question, right? In your opinion, Judge, basically this new legislation, the subchapter 5 law, doesn't that essentially render the position of the general unsecured creditor very, very precarious. I mean, in a traditional 11, they have no priority. They've not got no collateral, but at least they could form and organize a committee, hire
Oh, no
counsel,
committee.
and so forth. But in a subchapter 5 case, as long as, the debtor says, yeah, I'm giving my creditors the higher of the liquidation value and my net disposable income over 3 years, you're stuck, aren't you, Judge? I mean, I could do a 0% plan if in fact the facts back up that plan.
Look, we want to see creditors repaid. And yet if the debtor is doing honestly what they can do and can do it over 3 to 5 years, they can't go beyond 5 years. That is what the code provides for. And the fact that you can't band together with other creditors to have a creditors committee and have the creditors committee lawyer paid for by the debtor, I think you're right, makes it a bit of a handicap for a creditor in a subchapter 5. On the other hand, that's exactly why these cases can often be confirmed quicker and more cost effectively. I guess the bottom line is, if you're going to be a creditor, make sure you have collateral.
Yeah, as I was prepping this program, I literally wrote here, subchapter 5 is quite bad for general unsecured creditors. I mean, there's no two ways about it. It's not a good place to be. So
It's in large measure, I think, a function of Congress thought it was useful to have pretty much family businesses, sole proprietorships, and so on, to stick around and continue to do what they do when they're over leveraged. Because an awful lot of employment around the U.S. is in exactly these kinds of small businesses. Now, so Chuck, I think it's important when somebody sits down to think about, well, is my client a candidate for subchapter 5? To me, looking at section 1181 of Title 11, and by the way, the Bankruptcy Code is in its entirety in Title 11, but if you look at section 1181, it tells us those things that are applicable to subchapter 5 and those things from chapter 11 generally that are not applicable. I think that's an extremely important section to look at, section 1181. But now, Chuck, I'd like you to talk about the difference between a consensual confirmation and a non-consensual and why it matters and how it happens.
Sure. So a consensual chapter 11 plan means what it sounds like. Creditors support the plan. 2/3 in amount and 51% of those vote yes. Because plans in sub 5 cases tend to be so skimpy, let's say, it's sometimes difficult to get a consensual plan confirmed, notwithstanding the best efforts of the subchapter 5 trustee, because there's just not enough cash flow, let's say, from the business. In a consensual plan, the discharge occurs upon confirmation, whereas in a non-consensual plan, you have to complete your payments before you get the discharge. Like a chapter 13, the timing, does matter. I've not had a lot of success personally getting a consensual plan because most of my subchapter 5 cases were forced into bankruptcy because of a very aggressive, creditor, and these creditors often have, rightfully so, right, expectations. They, the debtor, let's say, breached the contract. The debtor owes them money, quite a bit of money, and they will not support a plan. And because of the size of their claim, it's very, very difficult to get that class to consent.
Caroline, how about you? You're the subchapter 5 trustee in a lot of cases. It's really your primary walking order to try to get people to a consensual basis. Are you having some success there?
I am. Part of the reason is that I tell them that if you confirm consensually, you don't have to pay me to be the dispersing agent. So that's kind of the chip that I like to play. I say, I know you like me, but do you really want to spend the money for me to dole out checks every month? And that's how we kind of show them on a numerical level that non-consensual is bad for creditors too. And that's what just happened in that case that I confirmed last week. In that case, I'm debtor side, but thank goodness the two creditors who voted no, they voted no, they sent in ballots that said no, but then didn't file an objection. These are creditors who are threatening litigation. They're former employees, you know, they had a bone to pick. I totally understand why they voted no, but they had no real reason. So I fortunately got their attorney, who is a very good bankruptcy lawyer, to get them to withdraw their objection. And then we were able to confirm consensually. So I've been pretty fortunate on that level, both on the trustee side and on the debtor side. The last non-consensual plan that I confirmed, I was the trustee in, and it wasn't that there were objections. There were just too many no votes. So, you know, there wasn't even a noisy creditor. That was a very odd one. But so I'm still the
Too many
dispersing
no
agent.
votes or too many non-votes?
No votes, actual rejections. Sorry,
Okay.
thank you for that clarification. And rejection and non-votes as well. Out here, at least some of our judges believe that a non-vote is a no vote. So in any event, that's a whole other topic we could spend 20 minutes on, but we won't. So in that case, I continue to serve as the dispersing agent. My assistant and I write out the 3 checks a month, and I don't charge very much for it, but anyway, that was the only non-consensual confirmation I've had so far.
Okay. Chuck, before we leave this slide, I'd like you to highlight again why the absolute priority rule is a non-starter in some Chapter 11s and is such a boon to subchapter 5, because there is no such thing as the absolute priority rule impeding confirmation of a plan.
Right, so traditionally, the way we scheme around the bankruptcy code's absolute priority rule to allow equity, the owner, the current owner, to retain ownership of the company post Chapter 11 was to have the owner put in money, new value, and exchange the new value, the money, that debt for the reorganized debtor's equity.
Essentially buying their equity back, right?
Buying their equity back, and you know, you want the new value contribution to be substantial. We're not talking 5,000, 10,000. I believe it depends on the facts of the case, but it's got to be meaningful. Subchapter 5 does not have the absolute priority rule. As long as the plan satisfies you know, the best interest test, and pays creditors the higher of the liquidation value or the 3 years of net disposable income, you can cram the plan down over an objecting class, even if every single creditor in that class votes against the plan. So it's a very powerful tool. We had a contested confirmation case out here. I'm embarrassed to say our fees were much higher than, you know, they should have been. But we had experts, and we litigated the liquidation value of dairy cattle. And this was the only remaining commercial dairy in the state of Hawaii. That just goes to tell you that you know, the cost of feed, just the cost of water out here in Hawaii is just prohibitive. So almost all of the milk that we drink out here comes from the mainland, virtually all of it. But in that case, the objecting creditor argued that our cattle was worth a lot more if shipped to the mainland, and we had to bring in evidence regarding the cost of freight and, you know, shipping versus flying the cattle, etc. Anyway, ultimately we prevailed, but the creditor ended up appealing that confirmation order because the plan was a 0% plan.
Okay, so let's get Curtis back in the game here. Curtis, let's talk a little bit about one of the items here that is different in a subchapter 5. First of all, tell us what has to happen in a regular Chapter 11 in the way of payment to the United States Trustee's Office. and how it's different
Ah,
in chapter 5.
Yes, thank you. My favorite topic, U.S. Trustee quarterly fees. So in a regular Chapter 11, there is a user fee essentially called the U.S. Trustee quarterly fee, in which debtors are obligated to pay a quarterly amount based on the amount of their disbursements, a percentage, a small percentage, to operate in the Chapter 11 system. That fee does not exist in subchapter 5. So it is yet another example of the benefits of subchapter 5 over regular Chapter 11.
But there is a fee paid to a chapter 11 subchapter 5 trustee. What is your office's position about whether the court ought to force that issue even before the plan is confirmed? That is, pay the trustee as you go, perhaps monthly.
Yeah. So first of all, typically the subchapter 5 trustee fee will be lower than what the U.S. trustee quarterly fee would be. So it's still an advantage. And our position generally is that we request the court to have the debtor set aside a small amount, $1,000, maybe $2,000 a month, set aside in a separate account, either in their own separate account or paid to the trustee to be held in trust, to ensure that the subchapter 5 trustee gets paid.
Okay, great. Now, Chuck, the word exclusivity is under one of the advantages of sub 5. Tell us what exclusivity means in the regular 11 context and in the sub 5 context.
Sure. So during the regular Chapter 11, only the debtor in possession may file a reorganization plan, may propose a reorganization plan during the first, boy, it's been so long since I've dealt with exclusivity. What is it, 120 or 108?
120.
120. Thank you. Okay. And for cause, the court can extend the exclusive period. So this is called the exclusivity period by practitioners. It's really an advantage to be able to come out the gate and propose a plan and solicit acceptance of the plan, right? We're in charge. The debtor in possession is in control, so to speak. But in a regular Chapter 11, it is possible, and sometimes is in fact the case for third parties, creditors, and others with standing to propose their own plan, a competing plan, so to speak. In a subchapter 5, there is no other plan allowed. Either the small business debtor confirms its plan, gets another chance or two, or the case gets converted or dismissed. But there is no opportunity for creditors to submit a competing plan in a subchapter 5.
Okay, so a couple disadvantages to sub 5. Caroline, would you hit these topics, please?
Sure. Well, I'm not sure. We talked about this, why conversion to Chapter 7 is on here, because that's a possibility in every Chapter 11. But I do have a fair amount of conversions on my cases, just because they probably shouldn't have been in Chapter 11 at all. They probably just didn't really, they had one big thing they were waiting on. You know, they said, oh, we've got this contract in the hopper, and it never came through. So that does happen. In one of the cases that was converted to Chapter 7, I stayed on as Chapter 7 trustee. They don't really do that anymore. That's just a function of our U.S. trustee's office. I think that the panel trustees, the Chapter 7 panel trustees, got upset about it. But the other thing here is the removal of the debtor in possession. And I alluded to it earlier because this is kind of a near and dear to my heart topic. So I mentioned earlier, it's the same criteria that you would get a Chapter 11 trustee appointed, and that's fraud, dishonesty, incompetence, gross mismanagement of the debtor's affairs, or failure to perform the obligations of a debtor under a plan. It's typically a creditor who brings this type of motion to remove the debtor from possession. If the court finds any of those things, it's a shall. The court shall order that the debtor shall not be a debtor in possession for cause. So this has happened to me twice, and this happened to me twice in 2020, so the very first year of SBRA. And in the entire district, there were only 3 cases where the debtor was removed from possession, and I had 2. So they were really, really interesting cases, though. And that simply means my role expands from a subchapter 5 role, which, like I said, is a facilitative role to an actual managerial, real Chapter 11 trustee role. And the first one was an individual who owned 6 pieces of property, and I simply collected rents and paid the mortgage and then sold them. So that was easy. The other one, not so easy, was a bail bonds company, which fortunately for me, they'd already stopped writing bonds by the time they filed Chapter 11, and they had become basically a collection center, a call center. So fortunately, I wasn't hiring bounty hunters and trying to track down people who had skipped bail, but instead, found a way to manage their collections more efficiently. And I hired outside collection agents, et cetera. So that is something that I think, as the slide says, some might consider a disadvantage of sub 5. However, that can happen in regular Chapter 11 too, based on the same criteria.
Yeah, so I see both of these things: conversion to Chapter 7 from Chapter 11, or removal of debtor in possession. Those aren't really disadvantages of sub 5, with this one little caveat, and that is a subchapter 5 trustee is given access to what's going on at the business in a way that doesn't really happen in regular Chapter 11. And so if the subchapter 5 trustee sees that you've got a fraud that's running the subchapter 5 debtor, or an incompetence or so on, it really is incumbent on the subchapter 5 trustee as an officer of the court to come in and say, Joe ought not to be running the show any longer here. And
Yes.
that's pretty devastating to a Chapter 11 sub 5 debtor.
That's right. And in fact, that's another subsection that's new, that the subchapter 5 trustee, for cause again, can investigate the conduct, assets of the debtor, file a statement of investigation, et cetera. And I had a judge recently, within the last couple of months, just say, there you go, Caroline, I'm giving you all those powers. So like Judge Collins alluded to, it's a pretty heavy situation when the sub 5 trustee is looking over you that way.
Okay, so I want to take a little pause in the action here, and we have a question in the chat box, and it's from Pablo, and it says, Chuck, perhaps you can answer this one. Who usually appears on behalf of a corporate debtor in possession at a Chapter 11 meeting of creditors?
Sure, and Curtis will tell you that the person or persons that should appear are those with knowledge about the debtor's financial affairs. Typically, the president, and if they have a CFO, the chief financial officer should appear and answer questions. The 341 meeting of creditors typically takes, maybe out here anyway, 60 to 90 minutes.
Okay.
And I think it's also worth mentioning that the debtor has to designate a responsible person to fulfill the obligations of the bankruptcy code. And so it's typically that responsible person who will be appearing and testifying.
Great. Now, Curtis, at this point, we were going to talk about the U.S. trustee's role, and we had a slide on that, but the truth is you pretty well hit all that territory. So I'm going to go back to the screen share and talk about some practical tips that all of you can share with us. Caroline, or now let's start with Chuck. Chuck, how do these Chapter 11, particularly sub 5 cases, come to you in the first instance? How do you generate that business?
I've yet to figure out how to advertise my services to the public, and I've been doing this for a long time. It's not, when people ask me what kind of law do you practice, I always get not always, but I often get kind of well, I hope I don't have to ever use you.
Oh, all the time.
So it's really, Judge, seriously, a referral business. And it's referrals from accountants, referrals from other practitioners.
Caroline, how does the work come to you?
Same as Chuck, I would say. And in addition, me being the subchapter 5 trustee has brought in thrown a lot of cases my way, because someone will say, oh, I've heard about this new thing, newfangled Chapter 11. And they say, oh, I know just the person for you. So I can convince them that I'm one of the most experienced people in sub 5.
Okay, so Caroline, if you're filing sub 5 debtor cases, how much are you charging? Now you're in Central District of California, so you're play based.
Yeah, this is gonna bowl everyone over. Well, actually, I'll say, in the last one that we confirmed, our total bill was about $90,000. I would say for my firm, we would take a retainer of about 50,000. But I've seen my debtor cases, much smaller businesses, take 10,000, 20,000. So you can definitely find a sub-5 attorney if you have a small enough case that would take 10,000, I would say, just to get your filing going. And that would have been an impossibility for traditional Chapter 11.
All right, so Chuck, you're in a different market. You're in Honolulu. So what kind of rates are you charging on a regular 11 and then on a sub 5?
Well, yeah, so the last regular 11 that I did, just fairly substantial 11, we asked for $100,000 pre-petition retainer. Now, the standard retainer that I quote for a sub 5 is 25,000. And I explained to the client, look, this is not going to carry you all the way through. You can expect 50,000 plus, okay? There are, as you alluded to, regional differences, you know, and what is the blended hourly rate that the client's ultimately going to have to pay. I'm guessing, based upon what I've seen down in Guam, the blended hourly rate for practitioners down there may be, you know, it's quite low, even relative to Hawaii, maybe 250 an hour, partner associate. Out here, I'm going to say it's 400, okay, plus or minus. Probably for LA, for Caroline, it's, you know, 500 plus.
My rate is $595 an hour, and I'm right in the middle because we've got some sub 5 trustees who are at national firms. So they're closer to 700 an hour.
All right, so we're talking about money because there is money to be made in bankruptcy. And Caroline and Chuck are perfect examples of making a really nice career out of this kind of work. But we've got one more item on the slide. I'm going to turn to you, Curtis, because this is something that may be foreign to people. What does the phrase cash collateral mean, and what are first day motions, if you would, please?
Sure, thank you. So cash collateral, of course, refers to the debtor's cash that serves as part of the collateral for a secured lender. So if the bank gives a loan to a debtor business, typically it's going to take as its collateral all the hard assets, but also the cash receipts as its collateral. So when you file for bankruptcy, you are not allowed to use the bank's cash collateral without either consent or court approval. So it's very important to either get one or the other, get consent or file a motion to approve the use of cash collateral. Those are typically often granted as long as the debtor provides some sort of what's known as adequate protection payments to the lender, but you cannot ignore that requirement because it is a basis to dismiss the case if you violate that rule. There's a lot of other typical first day motions. They're not described in the bankruptcy code, but they are there in order to facilitate the practice. In other words, if you want to pay your employees, but they are owed money for past wages, that's a pre-petition claim. Normally, you can't pay that until the plan confirmation. But of course, if you want your employees to stay on and keep working, you need permission to pay them immediately. And so you come in with a first day motion to pay wages. So there's a number of standard first day motions that come before the court very quickly, first or perhaps second day in the case.
And Chuck and Caroline, this is exactly why if somebody walks in your office today for a bankruptcy that has to be filed tomorrow and it has to be a Chapter 11, you're going to take a pass on that, aren't you? Because there's just too much prep.
I am. Yes.
Well, I would actually say this to the client, okay? If you don't have to make payroll in the next week and you don't have to write any checks in the next week, then as long as you give me a big retainer, I'll take the case.
Okay, there you
Because
go.
I can do the, you know, wage and payroll motion and the cash collateral motion as long as there's no imminent use of property of the estate.
Okay. Now we're in the home stretch here. There's a slide about exempt property. For those that attended the consumer portion of our program 2 weeks ago, we talked about exempt property a lot. It does come into play in a Chapter 11 or sub 511 if it's an individual debtor. Just make sure you understand what those exemptions are. Now, Guam, like every other jurisdiction, has its own local rules and its own bankruptcy forms. You're going to want to study those and understand what is expected in Guam and likewise in the Northern Marianas. Look at the local forms and rules as well. But here's the one thing above all, if you're going to do any kind of work as a sub 5 practitioner, that is go to the Bible. That is a treatise written by Judge Bonfeld from Atlanta, Georgia. It's free to everybody. This is the website link. He updates it periodically. Every issue that comes up in sub 5 is addressed in his treatise. And Caroline, you consult it all the time, don't you?
Oh, absolutely. All the time. It's the best. Such
Okay.
a great comprehensive, and he updates it too. It's not copyrighted. He says, send it to everyone you know. Professors can use it. Anyone can use it. So
That's your study guide. That's your Bible. But on top of that, as you come through your practice with questions about sub 5, Caroline, is it fair to say, and Chuck, is it fair to say they can just call you and have a chat about what they need to think about for their client?
Sure. Absolutely.
Yeah, absolutely. And you know, I think it's really important for small business owners to understand their options. 9 out of 10 calls don't end up with a bankruptcy filing, but you know, the business owner at least should understand why a bankruptcy is not recommended for them.
Okay. Well, look, we're actually in overtime now. Nobody wants to go into overtime on a early Tuesday morning in Guam and Saipan, but I really want to thank our panelists today. Curtis Ching from the U.S. Trustee's office in Honolulu, Chuck Choi from the Choi and Ito case or law firm that is in Honolulu, often practicing in Guam, and Carolyn Djang as well. You've been terrific. It's been fun work with you, and I really appreciate your sharing your knowledge with our practitioners in Guam and Northern Marianas. With that, thank you very much. Have a good day.